Welcome to my channel, All for Health with Jane. Family, we are still on the Senzo Meyiwa trial. Yesterday, when the court adjourned, Judge Rathas indicated that today he will need to have Pinky Vithalingham in this court to come and clarify some issues here. The reason is Judge Rathas says he was once accused of not allowing a witness to present the Vodacom documentation because that person was not from Vodacom. And now today, Colonel Steyn has to present information that is about Vodacom. So when Advocate Mnisi is indicating to Judge Rathas that Colonel Steyn is not allowed to do that, Rathas says, okay, I will call Pinky Vithalingham and Steyn will be here as well. Colonel Steyn will show us how he developed this document. Pinky will come and do whatever that Judge Rathas would like Pinky to do in this court. So this morning, Pinky could not make it to this court, and when Advocate Mnisi wants to know whether to continue with this cross-examination or not, you know, Judge Rathas doesn't listen. He doesn't listen to what Mnisi is saying, but instead, he's just on top of him. Family, when he was just supposed to say, okay, because Pinky Vithalingham is not here, you continue with your cross-examination until Pinky comes. He doesn't say that. You know, he even goes to an extent of quoting some laws and sections that says when, as a court, as an official of this court, he has the right to call a witness at any stage as long as he doesn't understand, or maybe as long as he wants clarity. But I don't think that was what Mnisi was saying. Family, let's listen to this clip as Advocate Mnisi is trying to indicate to Judge Rathas that, in fact, to request that should I continue or not, and Judge Rathas not giving him, you know, enough time to say what he wanted to say. Family, let's listen.
Is the court, madam?
Yeah.
I'm requesting the court to make a clarification here because the witness was still under cross-examination.
Yeah, he's still under cross-examination.
So I'm putting my cross-examination in abeyance in order to attend the issue
that
were raised by the court.
If you want us to do it the other way, you can do it. Because you must remember this evidence came after he said he composed the document.
Yes.
Now, I just wanted to know how did he compose it. But if you don't want to hear that, there's no problem. I can ask that after you've cross-examined. You can take down that concoction.
No, I just wanted to clarify, my lord.
No, fine. Continue with the cross-examination.
We are suspending actually we're putting my cross-examination in abeyance for him to continue.
Let me not do that.
With this clarification to the court.
Let me not do that. Are you saying it's illegal?
No.
Okay,
no. I just wanted clarification, my lord. Because
fine, no problem. I thought we all read section 167 and 168. I'm acting in terms of that.
That is the case, my lord, is fine. Then we can put my cross-examination in abeyance and allow him the space to clarify the court.
That section doesn't say that. Can you give me the 167 there? Yeah, it's 167 and 186. You don't have a charge? Yeah. Just read 186 and 167.
167 reads
Mr. Ramasipiri will read 186.
Reads as follows.
So that He reads 167, you read 186.
The heading is Court may examine a witness or person in attendance. The court may at any stage
Yeah, that's what I'm using, at any stage.
of
right?
criminal proceedings examine any person other than an accused who has been subpoenaed to attend such proceedings or who is in attendance at such proceedings, and may recall and re-examine any person, including an accused, already examined at the proceedings, and the court shall examine or recall and re-examine the person concerned if his evidence appears to the court essential to the just decision of the case. Then
Yeah, fine.
section 186.
Why don't Mr. Ramosipit must read it? You don't have a... You don't have the...
Section 186, probably. You can go 186.
186 is that side.
I can't see it. No, this thing is too small for me. Well, read it for me.
Mr. Ramsipil has asked me to read it.
Okay.
Court may subpoena a witness. There's a heading of the section. The court may, at any stage of criminal proceedings, subpoena or cause to be subpoenaed any person as a witness at such proceedings, and the court shall so subpoena a witness or so cause a witness to be subpoenaed if the evidence of such witness appears to the court essential to the just decision of the case.
Okay. Yeah, it's 167. Yeah, but continue, Mr. Mnisi. You've removed that thing. Okay, fine. Yes, Mr. Mnisi, you can continue with your cross-examination.
I'm not so sure, Madam. The court will recall yesterday that it raised the possibility that Mrs. Pinky Vittillingham should be here. I'm not so sure whether the state has addressed the court in that regard. Thank you, Madam.
No, he's already told me that he's not available today. He says he's available tomorrow, and I said, when I intended to call it, it was because I was being accused of letting a witness who is not employed by Vodacom of using Vodacom documents. And on second thoughts, it's obvious that this very witness, Colonel Steyn, is the one who composed the document, not Vodacom. Vodacom gave the police 6,296 pages of Section 205 numbers. Is that not so?
Yes.
And Colonel Steyn then says he went about his job as an analyst. Eventually, he composed this XKKK 5C, triple K 5C. That's why it was arising. But I don't think it's necessary because he is the author or the compiler of the very document which he characterizes as KK5C. And that KK5C is it's a consolidation of about 3 other numbers. Okay, you heard me. Then continue, sir.
Thank you, Madam. Mr.
Family, when we thought that is enough, the drama in this court doesn't end. Now we're fighting over, don't call him sir, don't call him mister, don't call him colonel. We're fighting over petty things when this case has to continue. Guys, we want to see justice for Senzo. This case needs to end. Family, let's listen, as they argue for being called. Do not call him colonel, do not call him sir, call him this. Let's continue and watch, family, and listen as well.
Mr. Steyn, the compilation of cell phone data by Vodacom is governed by the provisions of Section 25 of Act 2002, which is the Electronic Communications and Transaction Act. And that is the authority that empowers them to compile cell phone records and data. Now, in your case, what body of legislation or authority enables you or empowers you to compile all the information that you just presented at court here?
My Lord, did he address me or Mr. Steyn?
The address is Colonel Steyn.
No, Mr. Steyn.
Okay, fine.
Well,
On his behalf, Colonel Steyn, may you answer that?
The investigation officer, like I already mentioned in court, applied through the normal legal way to get hold of the documentation. It's been signed by a magistrate, and in that way we receive it in a legal way.
Twake lapha uphike umthetho okugunyaza ukuthi wena wakhe le document njengoba uthi wena uyakhe le document cha kusho ukuthi ke umphenyi kuleli cala uyena applyayo ke bese ke imanje nayo iyasayina ukuze ikwazi ukuthi igunyaza ukuthi kwenziwe lo msebenzi.
That I understand. The investigating officer applies from the magistrate to approach Vodacom, for Vodacom to supply them with particular information in relation to a particular cell phone. That I understand. I want to know, in respect of the police, what body of authority do you have or legislation that authorizes you to do exactly what Vodacom does?
I received a sworn statement from the investigation officer, which authorized me to do the necessary analysis for him.
Tike umuphike umthetho lo gunyaza amaphoyisa ukuthi awasebenzisane nalokhu okukhishwa uVodacom. Asithi ke cha umphenyi uthole istatement esivela kumphenyi esiyisona statement esamgunyaza ukuthi awenze lo msebenzi.
My Lord, if I'm not mistaken, I think it's Section 36 of the Procedure Act, which allows me to make use of any exhibit to prove that the crime has been committed. But I can be wrong. I know there's a section which allows us to work on that.
Aticanga ukuthi khona Section 36 okuwona umgunyaza ukuthi asebenzisene inanoma yini ukuthi alethe isiqiniseko sokuthi kukhona ubugebengu obenziwe.
I'm going to request you, Mr. Steyn.
You don't want to call him Colonel Steyn?
Sir, I'm going to refer you I'd rather refer you to sir. I always forget this phrase, sir. But in any
I'll
event,
do it on your behalf. Whenever you want to address him, you must just indicate to me, and I'll tell him, Colonel Steyn, Advocate Mnisi is asking you a question. No
but
problem.
the court does not even have to do that, my lord, because from where I'm standing, I don't think that I'm committing an offense.
No, you're
when
not.
I refer to him as Mr. Steyn, that's not an offense. It can't be an offense, my lord.
My Lord, I'm also an officer of the court. I just want to establish the difference between a title and a rank. Because Colonel Steyn is an ex-police officer, and a title remains with him until he dies. So why are we keep on calling him Colonel if he's no longer a police officer?
He prefers that way.
No, my Lord,
That's what he told
can we
the court.
get a direction from the court? We cannot get directions from the witness. He will remain Mr. Steyn. In that docket, in that witness box, is Mr. Steyn. He's no longer a police officer. He's an ordinary citizen of this country.
I'm still holding my rank, my Lord.
Yeah, but we'll address you as Mr. Steyn, not as Kennedy.
My Lord, then I've got no purpose in court anymore. Because I get testified, give myself my witness statement is when I was a colonel in the police.
Or is that what he's implying, that because you're no longer a policeman, you can no longer testify?
Yes, that's correct.
No, I don't think he means it that way.
My Lord, let me also rise as an officer of this court. My Lord, for lack of better word, this is becoming a joke. For
I agree.
the sake of brevity,
I agree.
let progress be made.
Yes. In what way?
My Lord, whether he's a colonel, he's a master, as long as there's no insult, let us proceed.
Yes, okay.
My Lord, on the same vein as the court would normally refer me as Mr. Mnisi, I'm an advocate. My title is I'm an advocate. But throughout this proceeding, the court has been referring to me as Mr. Mnisi, and I never took any offense on that. So I also find no logical reason for Mr. Steyn to take an offense when I'm referring to him as Mr. Because that's not an insult. In any event, when he comes in there, a person says a Mr. It does not say a colonel. That's not an insult.
Yeah,
and I also find it very...
Can you continue, Mr. Mnisi?
That is exactly what the court has just done. The court does not address me as advocate. It says Mr. and I'm not taking an offense.
What does what does the ethics documentation state how advocates address the court?
The authority that the court has just referred us, I think it was the day before yesterday, it says for as long as you do not use a derogative word towards the witness, any word that symbolizes that you are respecting him, then that is fine. So I'm saying to him, Mr. He does not
fine.
want me
No
to
problem.
refer to
Okay.
him as Mr.
You
He wanted the court to make a ruling on this one.
No, I'm not making a ruling. You can continue calling Mr., but I will refer you as Colonel Steyn, okay?
Thank you, man.
Thank you, my lord. Now, Mr. Steyn, I wonder if you understand me. I say Vodacom derives their power or authority to deal with or to provide cell phone records from a particular number through the legislation that I've referred you to. Now, is there... now my question is, what body of the law empowers? Law means it can either be a body of the law, I refer to a legislation, a policy, things such as those that are saying to the police, through this you can do you can go and investigate a person's cell phone in order to get a particular information that you can then go and use at court. I want that authorization. What is that authorization?
That authorization, according to me, is Section 205, my lord.
Okay.
Njengoba lapha imuphi umthetho okugunyaza ukuthi uyiphoyisa uhambe bese uyohlola umakhala ekhukhwini womuntu ukuthi uzosebenzisa la ecourt osethi yena cha mina ngibona sengathi usection 225.
Thank you. Is that the same section 205 that authorizes you that after you have received information from Vodacom for your own purposes of analyzing that information that you had received from Vodacom, you also need to add your 2-hour grace in your analysis in order to come to a particular result?
My lord, I can just mention the 2-hour rule got nothing to do with a Vodacom statement.
Exactly.
Thike hayi mina ngibona sengathi ke njengoba ubuzothi umthetho iwona yini lo mthetho lokugunyaza ukuthi uphinde unezezele usebenzise lo mthetho lokuthiwa i-2-hour rule. Asethi ngibona ukuthi usemqoka lokho ukuthi ungafakwa la kulolu daba le ndaba ye-2-hour.
And that is exactly my point. What are the bases? Where do you derive authorization for you, having received information from Vodacom, for you to analyze it? you say you're making your own 2-hour grace into the information that you derive from Vodacom.
If your XRY program tells you that you must add 2 hours, and you got a document from Vodacom with, let's say, normal time on it, then you know you must add 2 hours. It's simple like that.
Athe uthatha phi ke lokho ukuthi uzofaka le 2 hours lena njengokuthi ukusebenzisa lo mthetho 2-hour grace wathi no the XRY program iyona ekutshela ukuthi umuntu oqhubeka usebenza ufanele ufake ama-hour amabili.
With due respect, Mr. Steyn, I'm going to request you to make that information that says to you, if you're working on an Excel and information from Vodacom, you need to put in 2 hours thereon. But thank you. That's just a request.
Family, that's Judge Rathas and his team. Anyway, thank you, family, for watching this video to the end. Please, let's meet in the comment section. Let me hear from you. What are you saying? Is it right? What we hear here, is it okay? Thank you, family. Please do not forget to like this video before you leave. Subscribe for my channel if you haven't done so yet. It is very important for the growth of this channel. Bye.